Government and Court Access to Private Sector Information, Right to Financial Privacy Act of 1978. The Right to Financial Privacy Act of 1978 represents a critical piece of legislation that safeguards individual privacy by limiting federal government access to personal financial records without lawful authorization. This act was a response to growing concerns about privacy invasions, mandating that government agencies must provide notice and opportunity for account holders to challenge records requests, except under specific circumstances such as law enforcement investigations. Bank Secrecy Act of 1970, BSA. The Bank Secrecy Act, enacted in 1970, is primarily focused on combating money laundering and financial crimes. However, it also impacts privacy by requiring financial institutions to keep detailed records of customer transactions and report suspicious activities that might signify money laundering, fraud, or other financial crimes. While essential for law enforcement, the BSA raises concerns about the extent of surveillance and the potential for overreach into individuals' financial privacy. Access to communications, wiretaps. Wiretapping, the practice of secretly listening to or recording someone's telephone conversations, is a powerful tool for law enforcement, but also a significant privacy concern. The legal framework for wiretaps in the United States is strict, requiring law enforcement to obtain a court order based on probable cause to believe that the wiretap will uncover evidence of a crime. This process is designed to balance the government's need for information with the individual's right to privacy. Electronic Communications Privacy Act, ECPA. The ECPA, enacted in 1986, extends privacy protections to electronic communications. It addresses various aspects of telecommunications privacy. Emails. The ECPA requires law enforcement to obtain a warrant to access recent emails, though older emails may sometimes be accessed with a subpoena or a court order, less stringent than a warrant. Stored records. The Act also covers access to stored electronic records, necessitating different levels of legal process depending on the age and type of data. Pen registers. Devices that record the numbers dialed from a telephone require a court order for their use by law enforcement, indicating a lesser expectation of privacy for this data compared to the content of communications. Communications Assistance for Law Enforcement Act, CALEA. Enacted in 1994, CALEA mandates that telecommunications carriers and manufacturers of telecommunications equipment modify and design their equipment, facilities, and services to ensure that they have the capability to enable law enforcement agencies to conduct electronic surveillance pursuant to court orders or other lawful authorizations. CALEA represents a significant federal effort to ensure that technological advancements do not outpace law enforcement's ability to access communications for legal purposes, again highlighting the tension between privacy rights and public safety. Conclusion. The intersection of law enforcement and privacy in the context of accessing private sector information is a complex and evolving area of U.S. law. As technology advances, these laws must continually adapt to ensure that they provide adequate privacy protections, while still enabling law enforcement to effectively combat crime and protect national security. Balancing these competing interests remains a pivotal challenge for lawmakers, courts, and society as a whole. Government and court access to private sector information, navigating the complex landscape of national security and privacy. The balance between national security and individual privacy rights has been a contentious issue in the United States, especially in the digital age. The government's access to private sector information under the guise of national security has expanded significantly over the years, raising critical questions about privacy, civil liberties, and the scope of government surveillance. This essay explores the evolution and implications of legislation and policies designed to facilitate government and court access to private sector information, focusing on the Foreign Intelligence Surveillance Act of 1978, FISA, the USA-Patriot Act, the USA Freedom Act of 2015, the Cybersecurity Information Sharing Act of 2015, CISA, and the implications for civil litigation and privacy. National Security and Privacy, Foreign Intelligence Surveillance Act of 1978, FISA. Wiretaps. FISA was enacted in 1978 as a response to concerns over government abuses of surveillance powers for national security purposes. The Act established procedures for the physical and electronic surveillance and collection of foreign intelligence information between foreign powers and agents of foreign powers within the United States. FISA's provisions for wiretaps required the government to obtain a warrant from the Foreign Intelligence Surveillance Court, FISA, a specialized court with the authority to oversee requests for surveillance warrants against foreign spies inside the United States. Emails and stored records. FISA's scope expanded with technological advancements, encompassing not just wiretaps, but also access to emails and stored records. The Patriot Act, passed in the wake of the September 11th attacks, amended FISA to facilitate easier access to electronic communications and related records. This expansion aimed to adapt to the digital age's challenges, where terrorists and foreign agents increasingly used online platforms for communication. National security letters. Another significant aspect of FISA is the use of national security letters, NSLs, an administrative subpoena tool. NSLs require recipients, typically telecommunication companies, financial institutions, and internet service providers, to provide specified customer information to the FBI without disclosing the request's existence to the customer. This tool has been criticized for bypassing traditional judicial oversight and potentially infringing on privacy and free speech rights. Amendments Act, Section 702, 2008. The FISA Amendments Act of 2008, particularly Section 702, authorized the collection of foreign intelligence information from non-US persons located outside the United States without a warrant. This provision has been pivotal for US intelligence agencies in gathering significant amounts of foreign intelligence, but has also raised concerns about the incidental collection of US citizens' communications and the potential for abuse, uniting and strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act of 2001, USA-Patriot Act. The USA-Patriot Act, enacted shortly after the September 11th attacks, significantly expanded the government's surveillance and investigative powers. Among its many provisions, the Act allowed for roving wiretaps, searches of business records, and the expanded use of NSLs. Critics argue that the Patriot Act eroded privacy protections by lowering the standard for surveillance and expanding the types of information the government could access. The USA Freedom Act of 2015. In response to the public outcry following the revelations of widespread surveillance practices by the National Security Agency, NSA, Congress passed the USA Freedom Act of 2015. This act aimed to reform certain aspects of the government's surveillance programs, including ending the bulk collection of telephony metadata under the Patriot Act. It introduced more stringent requirements for the collection of call detail records, including the need for a targeted selection term and enhanced transparency and oversight measures. The Cybersecurity Information Sharing Act of 2015, CISA. CISA represents another critical piece of legislation in the national security versus privacy debate. It encourages the sharing of cybersecurity threat information between the private sector and the government, aiming to enhance the country's cybersecurity posture. However, privacy advocates have criticized CISA for potentially allowing the exchange of personal information under the guise of cybersecurity, with insufficient safeguards for privacy and civil liberties. Civil litigation and privacy. Compelled disclosure of media information. Privacy Protection Act of 1980. The Privacy Protection Act of 1980 offers protections against government searches and seizures of work product and documentary materials possessed by individuals reasonably believed to have a purpose to disseminate to the public a newspaper, book, broadcast, or other similar forms of public communication. This act is crucial for protecting journalists and their sources, especially in an era where the collection of electronic data is ubiquitous. Electronic discovery. In the realm of civil litigation, electronic discovery, e-discovery, has become a significant aspect of legal proceedings. The process involves the exchange of information in electronic format, e.g., emails, instant messages, documents stored electronically, between parties in a lawsuit. While e-discovery offers a powerful tool for uncovering relevant information, it also raises privacy concerns, as vast amounts of personal and sensitive information can become accessible during litigation. In conclusion, the intersection of national security and privacy in the context of government and court access to private sector information, presents a complex and evolving landscape. As technology continues to advance, the challenge of balancing the imperatives of national security with the fundamental rights to privacy and civil liberties remains a pivotal concern for policymakers, legal professionals, and the public. The legislative and policy measures discussed herein reflect ongoing efforts to navigate this delicate balance, though debates about their effectiveness and implications for privacy rights are likely to persist.